Okay, good afternoon, everyone, and welcome to Locust Project's LegalARTLink webinar covering the CASE Act, which is a new law that sets up a small claims tribunal. My name is Alan Gins Ayers. I'm an attorney and I'm the LegalARTLink director at Locust Projects. I'm also a working artist myself as a dancer and rehearsal director for Dance Now Miami, which is a contemporary dance company here in Miami. Before we get started, I just wanted to take a moment to thank our sponsors who have made today's presentation and all of LegalARTLink's public programming possible. Our lead sponsor today is the George M. Perez Family Foundation at the Miami Foundation. And we also have contributing support from the Community Recovery Fund at the Miami Foundation, Scott Hodes, Bradley D. and Susan Hauser, Jones Day, and the Marie Kennedy Foundation, and the Friends of LegalARTLink. Just a bit about LegalARTLink. For those who may not be familiar, LegalARTLink is an artist support program at Locust Projects that helps artists with legal issues they may be facing with the aim of empowering artists' careers. In addition to public programs like this one we are presenting today, we help artists with specific issues as they arise. LegalARTLink assists artists of all disciplines with any type of legal issue, whether or not it's related to their art practice. If you have a particular issue you're facing, you can complete the online form on our website or email LegalLink, LegalLink, at locustprojects.org. Please also keep an eye out for signups for our monthly office hours as well. And finally, because this is a legal presentation, it does come with a disclaimer. So the materials and information provided during this webinar are for informational purposes only. They are not intended to provide a legal opinion and do not constitute legal advice, which must be tailored to the facts of a particular situation. Due to regular changes in law and policy, the information provided during this webinar may not contain the most up-to-date legal or other information. Use of and access to this webinar do not create an attorney-client relationship between you and LegalARTLink, and you should consult an attorney for legal advice relating to any particular issue or problem. The purpose of today's webinar is to give you some information about the CASE Act and the Small Claims Copyright Board that it creates. We want artists to be aware that this is happening so that if artists are facing a copyright issue, they know what options are available to them. Today, we aim to take you through the current system for resolving copyright disputes and also to go through the changes that are being implemented by the CASE Act, as well as to give some general thoughts and principles about how this new system can help you protect your work. As an initial matter, I thought it would be helpful to have a quick review of copyright as a general subject. While many artists are likely familiar with copyrights as a general principle, it's probably helpful for our discussion to clarify what exactly we mean when we say copyright. Copyright is a type of intellectual property that is provided for in the United States Constitution. The Constitution gives Congress the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. The idea is basically that by giving people who make creative works and inventions, in the case of patents, the exclusive right to control their creations, that the government has incentivized creativity and cultural production. The Copyright Act gives effect to this clause of the Constitution by granting certain rights to the creators of the works for a limited time. The Copyright Act defines which types of works fall under copyright law, which are referred to as works of authorship. And these types of works are visual art, literary works, sound recordings, audiovisual works, so films and other audiovisual medium, dramatic works, choreographic works, whether or not they have a dramatic storyline, and architectural works. In order to receive protection, the works must be original. Now, the term copyright actually refers to a bundle of exclusive rights, which include the right to reproduce a work, to distribute the work through sales, to publicly perform and publicly display the work, and to make derivative works or adaptations based on the original work. The copyright is created as soon as the work is fixed in a tangible means of expression. If you are an artist who is creating original work for yourself, you almost certainly are a copyright owner, even if you have never registered your work with the United States Copyright Office. There are benefits to registering one's work, however, as we will discuss and which will become clear later. The Constitution did not intend for the exclusive rights of copyright to last forever. It does say that these rights are to be for limited times. Rather, the rights granted under copyright are intended to help provide for an artist's livelihood during his or her lifetime and to provide for their direct heirs. Currently, in the United States, the term copyright is generally for the author's life plus 70 years. After the copyright term is completed, a work that was previously under copyright will transfer into the public domain. While the Copyright Act grants ownership to creators solely by virtue of them creating a tangible original work, in order to enforce the rights under copyright, if they've been violated, copyright owners must do so in the federal court system. Copyright owners can first send a cease and desist letter demanding that an infringing act stop. And oftentimes this can resolve the case with, in order to avoid going to a federal lawsuit, but in order to get an order, a court order requiring that an action cease, or to recover any money that the copyright owner might be owed as a result of an infringing act, the owner will have to file a federal lawsuit. The judge can issue an injunction requiring that infringement stop and can award money damages. Today, we'll be covering a change to that copyright enforcement scheme that will provide an alternative to filing such a lawsuit in federal court. This change is implemented by a law called the Copyright Alternative in Small Claims Enforcement Act of 2020, which is shortened to the CASE Act. The CASE Act is the result of years of bipartisan congressional efforts to create an alternative to the federal court enforcement system by creating a tribunal within the Copyright Office that exists to handle smaller issues. This tribunal is called the Copyright Claims Board, or the CCB for short, and is a voluntary, streamlined process to handle copyright disputes. The CASE Act was passed in December 2020 as part of an omnibus spending bill and was signed into law by President Donald Trump on December 27th, 2020. As you likely remember, it was only a few months ago. The country was facing many severe issues at the time, including a dramatic spike in the number of COVID cases, as well as baseless disputes over the results of the November election. And as a result, coverage of the omnibus bill tended to focus on the more political aspects of that bill, which included spending and COVID relief issues. The CASE Act largely flew under the radar when that bill was passed. So that's why, if you haven't heard of it, it may be because it was overshadowed by some of these bigger issues. Now, the text of the act requires the CCB to be operational 1 year from the act becoming law, but it does allow for a 6-month extension. So given the timing of when that act was signed into law, this would put the timeline for the CCB to be active at December of this year, but it does allow the Copyright Office until June of 2022 at the latest, if they face delays because of COVID or otherwise, to make the CCB operational. Before delving into the new procedures created by the CASE Act, it may be helpful to take a look at the current system with which you may or may not be familiar. As I mentioned before, copyright is a federal right that gives certain exclusive rights for the economic benefit of creators in order to incentivize people to make and keep creating creative works. Disputes over these works must currently be brought in federal court, as we mentioned before. Federal courts have what's called exclusive jurisdiction, which means that you can't bring a copyright case in state court. Only federal courts have the power to decide these types of cases. But now federal court can be very expensive and time consuming. In addition, it's a technical and complicated process, which is very difficult to navigate on one's own without the assistance of an attorney. In the congressional studies that were done prior to the implementation of the CASE Act, Congress heard from groups that represented creators throughout the country, such as the Graphic Artists Guild, the American Photographic Artists, and the Alliance for Visual Artists. These groups were in general agreement that the barriers of entry that are involved with federal litigation effectively made copyright enforcement prohibitively expensive for many artists and small businesses. So simply put, it's just too expensive for artists to assert their copyright claims in federal court in most circumstances. So now we'll go through some of the details relating to a federal copyright lawsuit. Copyright law requires that a work be registered with the United States Copyright Office in order for the owner to bring a lawsuit. So like we mentioned before, while you have your exclusive rights to copyright as soon as your work is created, in order to enforce those rights in federal court, you do have to register your work. Now, before 2019, the courts of appeal in different parts of the country had different standards of how they applied when a plaintiff could file a lawsuit. In some parts of the country, a copyright owner could file a lawsuit if the owner had simply applied for registration. So if they went on to the Copyright Office, they filled out the application and they filed that application for registration with the Copyright Office, they could then file their lawsuit. However, in other parts of the country, the courts of appeal required that the registration be actually approved. So not only do they have to submit that application, but the Copyright Office had to review it and had to actually issue a certificate of registration in order for a prospective plaintiff to bring a case before a federal court. Now, in 2019, the Supreme Court of the United States decided a case called Fourth Estate Public Benefit Corporation versus WallStreet.com LLC. And in that case, the Supreme Court decided that the Copyright Office must actually approve the application in order for the copyright owner to file a lawsuit. So not since 2019, no matter where you are in the country, not only do you have to fill out the application for copyright registration with the Copyright Office, but they actually have to review it and approve that registration in order for you to file a lawsuit in federal court. This can cause some delays. Once an application is filed, it can take upwards of 8 months for a registration certificate to be issued, unless the applicant pays a high fee that can expedite the process. And even then, it can take several weeks to a month or more. Currently, the filing fee to start a federal lawsuit is $402. And this is only the fee to file the lawsuit. It doesn't include any of the costs associated with hiring an attorney to prepare the lawsuit, or and it doesn't include the fees involved to serve a defendant with a lawsuit. One benefit of a federal lawsuit, which we'll see by comparison later, is that the copyright owner can recover significant money damages under certain circumstances. Copyright owners can seek actual damages and profits, or the amount that they lost in revenue and licensing fees, or that the infringer gained by its unauthorized use of the protected work, but this does require proof of what those amounts would be. However, if the work was timely registered with the Copyright Office, and when we say timely registered, this means that the work was registered within 3 months of its publication or before an infringement took place. So you can only take advantage of these timely registration remedies that are available if you register your work before the infringement actually happens. So if you have a timely registration, then the copyright owner can seek statutory damages, which means they don't have to prove that they actually lost money or that the infringer gained profits or what those amounts were. Now, for timely registered work, statutory damages can start at $750 per work, but they can go up to $30,000 per work, or if the court finds that there was a willful infringement, it can go up to $150,000 per work. In addition, if the work was timely registered, then the copyright owner can seek attorney's fees and costs. And what that means is that they can ask the court to make the other side pay for their attorney's fees and costs that it took for them to file the lawsuit. So this is an example between the attorney's fees and the statutory damages that are available. This is an example of how registration of works can be very beneficial to copyright owners, especially when it's done before an infringement takes place. Problems with the current system. So with the digital age, infringement of copyrighted works on the internet has become very easy and very low cost to effect. At the same time, it's become more expensive and difficult to bring federal copyright claims in the court system. Many attorneys won't take a copyright case unless there's a potential for large statutory damages. As a result, for artists who may only have a single work that's been infringed and who don't have a timely registration for their works, enforcement in federal court is largely out of reach for that type of case. And as we've mentioned, the copyright system is intended to provide economic benefits to copyright owners in order to incentivize creativity and production. So if the ability to enforce those rights is diminished for those owners, this increases the incentive for infringement because the potential infringers know they won't really face real consequences. So that brings us to why the Case Act was created in the first place. Seeking to address these existing barriers to enforcement in the federal litigation realm, the Case Act hopes to create, or will create, a copyright claims board with within the United States Copyright Office that will hopefully provide an easier and alternative form to handle relatively small copyright cases. An important caveat is to note that because copyright law gives federal courts exclusive jurisdiction, participation in the CCB forum is voluntary. So they can't force cases to be decided within the CCB. Both parties have to agree that that's the correct place that those cases will be decided. Claimants who have smaller claims do not have to bring their claim before the CCB. They're always free to file a lawsuit in federal court. And on the other hand, respondents, who are the people who receive a complaint that was filed in the CCB, they will always have the ability to opt out of a proceeding in favor of a federal court proceeding. So that is one important caveat and limitation on what the Case Act will be able to provide in terms of an alternative forum. One reason that a respondent may choose to stay within the CCB, so if somebody has a claim brought against them and they're deciding whether or not to opt out or to stay within the CCB, they might choose to stay because the CCB has a limit on damages. So again, the CCB is supposed to be for smaller claims. And if we recall on statutory damages, the upward limit of that for non-willful infringement was $30,000 per work. So here we have a $30,000 cap per proceeding. So the potential exposure that somebody would have if a claim is being brought against them can definitely be smaller in the CCB than it would be in federal court. So that might encourage respondents to stay in the CCB in order to avoid a potential higher damages award against them. So again, for timely registered works, we have this split up again, where there will be an advantage for works that were registered prior to an infringement taking place. So for those works that are registered prior to that infringement, the cap will be at $30,000 per proceeding. So for a claim brought to the CCB, whether or not there are more than one work or more than 2 works being argued over, the most that a claimant will be able to recover is $30,000. And those statutory damages are capped at $15,000 per work, as opposed to that $30,000 or $150,000 for willful infringement in federal court. Now, for works that are not timely registered, the cap is $15,000 per proceeding, and statutory damages are capped at $7,500 per work. So, but you might notice here that unlike in federal court, these statutory damages are available even for works that are not timely registered. They are capped at a lower rate, but the statutory damages election is only available in federal court to works that are timely registered. So here you can, and here claimants would also have to make that election between whether they're going to seek the actual damages or the profits that the alleged infringer got from using the copyrighted work, or if they're just going to say that, you know, this statutory damage or this, the law has decided that this is the amount of harm that has been caused, and they can elect to take that instead. Another difference between the CCB and federal court is that attorney's fees are only available in the event of bad faith. So again, in federal court, if a work was timely registered, then the copyright owner could seek attorney's fees and costs against the alleged infringer. Here, however, the CCB can award attorney's fees and costs if there's bad faith. And that could be on both sides. So either side acting in bad faith, the CCB could award the other side attorney's fees that they would have to pay for the cost of bringing that claim before the CCB. In addition, if there's bad faith, in addition to being awarded attorney's fees, the CCB can dismiss the claim or even all of the claims that someone has before the CCB. So I am mentioning attorney's fees here, but it's worth mentioning that the CCB is intended to be structured so that a copyright claimant could go through the process without being represented by an attorney. Of course, many people will be represented by counsel as they go through this process, but it is being created and implemented with the idea that people will be able to sort of handle their own claims before the CCB. Registration. So another notable difference between the CCB and federal litigation is that a CCB claim only requires that an application for registration be made to the Copyright Office. So again, this is prior to 2019, this was the law in some of the country with respect to bringing a federal lawsuit for copyright infringement. But here for the CCB, Congress had said that a claimant only needs to file their application. Now, the CCB does need to wait until the Copyright Office actually issues a registration in order to make a decision on a case, but the claimant can bring the case even knowing that the CCB won't be able to finally adjudicate it until the registration is finalized. So in the event that the Copyright Office ultimately declines to register the work, so if they make the application and the Copyright Office says, no, this isn't copyrightable for whatever reason, then the pending claim before the CCB will be dropped. Now, this difference allows a claim to be brought a lot sooner if infringement is discovered before the work is registered. So if you're a copyright owner and you find out that somebody has been infringing your work, you don't have that work registered. If you wanted to file a lawsuit in federal court, you would have to wait for your application to go through that entire process. Again, right now, the waiting time is upward of 8 months, maybe even close to a year in order to get that registration certificate. But to file a CCB claim, all you have to do is file that application and you'll be able to bring the claim before the CCB. rather than have to wait for the certificate to be issued before starting your claim. So the exact details of precisely how the CCB will operate will be finalized in the coming months. But we do know that the basic framework of how the CCB will work, and I'll sort of take you through what that process will look like, as well as highlight some areas where we don't know exactly at the moment how things will play out or how the Copyright Office intends to implement this law. So the first step will be that the claimant will file a claim with the CCB. And pay a filing fee. We don't know at the moment what that filing fee will be, but it will most likely be less than that filing fee of $402 to file a federal lawsuit. Once the claim is filed, it will be reviewed by a CCB attorney to make sure that it's proper. So this is a difference also between a federal lawsuit and the CCB claims. So once, in a federal lawsuit, someone will just file a claim, and then it's up to the defendant to move to dismiss the claim if they think that it's not properly brought, or if it's not, if what they're suggesting isn't true or isn't, or they're saying that the conduct you've done is copyright infringement when it's not copyright infringement. But here, even before the respondent receives that claim, someone at the Copyright Office is going to be reviewing the claim to make sure that it, at least on its face, is alleging a copyright infringement or another type of case that is proper to bring before the CCB. So if that claim is proper, the CCB will instruct the claimant instruct the claimant to proceed with service of the claim on the respondent. So that means that the claimant will have to present its claim to the respondent, likely by what's called personal service, which means that you deliver the complaint to the respondent in person. Or they can waive that personal service. If the claim is defective, the CCB will notify the claimant, and the claimant can amend the claim within 30 days. So if they say, this is almost right, but you didn't, show that you're the actual owner of this work, then the claimant can modify their claim and refile it without paying an additional fee. And then if it's still deficient, the claimant will have a second chance to amend the complaint within 30 days without filing an additional fee. The CCB can dismiss a claim if it determines that it's unsuitable for determination by the CCB. For example, if there's a lack of evidence, if they're not going to be able to determine whether copyright infringement actually took place, or if there's issues that exceed the scope of the CCB's purpose. Step 2, which I did touch on briefly already, but it's service on the respondent. So after the CCB approves the claim, the claimant has to give notice and serve the complaint on the respondent within 90 days of the CCB approving the claim. So they'll have about 3 months to make sure that the respondent receives this claim once the CCB approves. And the notice that they give the respondent has to include the respondent's right to opt out of the proceeding. So again, one of the limitations that we have here with the CCB procedure is that it's entirely voluntary. So because of this, the Copyright Office wants to make it very clear, and the Case Act demands that the Copyright Office makes it very clear that it is a voluntary process and that the respondent does have a right to opt out. So when the respondent receives the claim that's been filed against them, they're also going to receive this notice that they have a right to opt out of the proceeding. And that if they do not opt out, they're waiving their right to have the matter heard in federal court and also waiving the right to a jury determination. So when a federal lawsuit is filed, it can go to a jury trial where a jury will ultimately determine whether or not copyright infringement has taken place. But here, instead of a jury making that determination, you're going to have a board of attorneys who work within the Copyright Office who have experience and expertise in the field of copyright law making that determination, rather than a jury who's being instructed by a judge and attorneys in the case. Now, again, service has to be made in person unless the respondent waives in-person service. And if they waive that service, meaning they say, okay, you can mail me the complaint or you can send it to me by email, then they'll have an additional time to respond than they otherwise would. So the next step would be the opt-out period. So again, the CCB process, and I cannot stress this enough, is entirely voluntary. No one can be forced to make their claim before the CCB or to defend a claim at the CCB. And every respondent has the right to opt out of a proceeding in favor of pursuing that matter in federal court. So after service of the claim, respondent has 60 days to opt out by providing written notice to the CCB. And one of the things that has not been decided yet by the Copyright Office is how this opt-out is going to take place. Some people are suggesting that the Copyright Office have an online portal through which a respondent could easily log in and opt out. Others are suggesting that a written or by mail system is better. So as the Copyright Office implements these procedures in greater detail, we'll know exactly how that opt-out is going to take place. If the 60-day period passes and the respondent does not opt out, then the CCB claim becomes active. In an active proceeding, the CCB will set a schedule for future conduct, which might include case management conferences. It might include some fact-finding or some settlement as well. Unlike federal litigation, CCB claims will not include formal motion practice, except that parties can make requests to the CCB for orders about case management and discovery. So the technical aspects and the sort of back and forth between the parties and the court, or in this case, the board, will be a lot more limited than in the federal court system. And this is sort of what I was mentioning when I said that this procedure would be more available and more accessible to a non-attorney or somebody who isn't being represented by an attorney, because the sort of like back and forth and filing motions that attorneys do in litigation isn't going to be had at the same level as it is in federal litigation. Likewise, discovery or the fact-finding part of a claim will be more limited in scope than in federal court. And the CCB can consider documents and testimony of parties and non-expert witnesses, but unlike in federal court, expert witnesses will only be permitted in exceptional cases. So again, we're sort of limiting the what is the scope of what's going to be considered before the board rather than in a federal court setting. Hearings and settlement. So the CCB may conduct hearings to resolve issues, and the parties may request, that should say may rather than pay, may request a conference with the CCB in order to facilitate settlement discussions. So the CCB, in addition to potentially adjudicating the claim, may also help to mediate this claim between parties so that they can come to a resolution on their own. And after receiving all of the documents and testimony that they need to make a determination, the CCB will issue a determination on a claim. There are some cases when the CCB could issue a default determination. So in the event that a respondent, doesn't opt out, so the CCB claim becomes an active proceeding, and then the respondent just either fails to respond or stops responding in an active proceeding, the CCB can enter a default determination under the following procedure. So this is again going to be somewhat different than in federal court, so in federal court, the court is not going to take this sort of detailed look at the case that the CCB is here. In a default determination before the CCB is going to require the claimant to submit evidence that supports its claim and the amount that it's asking for damages. The CCB is going to review that evidence, so it could be documents, it could be testimony, to determine whether they believe that this evidence that's being presented supports the claimant's claim, whether the claimant is showing that this copyright infringement did take place by the respondent and that the damages are appropriate. If the CCB agrees with the claimant, it will give notice to the respondent of the default determination, and the respondent will have an opportunity to submit additional evidence. And if the respondent does not respond to that notice, the default determination becomes final. So again, this is a little significantly more involvement from the CCB at these stages, filing a claim at the default stage, than a federal judge would have in a case. If a party doesn't like the decision that the CCB reaches, they can request for reconsideration, and they'll have 30 days after the final determination to submit a written request for that reconsideration. In addition, the Case Act instructs the Copyright Office to create an even more streamlined procedures to adjudicate claims for which the amount in controversy is under $5,000. So again, the caps here were $30,000 and $15,000 per proceeding, but for even smaller claims, the procedure that I just outlined might be even more streamlined and user-friendly, hopefully. I think it's important to talk about copyright users in addition to copyright owners in the context of the CCB. So we've largely been framing this discussion from the standpoint of copyright owners, but I also know from my work with artists in the community that many of you also use copyrighted work in your own art. And the CCB process may provide a more accessible forum for those seeking to defend their use of copyright art when it's being challenged, or copyrighted work that's incorporated into your own work when it's being challenged by the copyright owners. Control of copyright works are not absolute under the law and are subject to what's known as the fair use doctrine, which allows the use of copyrighted work for purposes such as comment, news reporting, criticism, and parody. However, because federal lawsuits can be extremely expensive to defend as well as bring in the first place, many would-be defendants end up paying settlements when they receive a cease and desist letter. The CCB may provide a forum through which users of copyright who believe that they are doing so under fair use can ask the CCB to make that determination. So again, the CCB, it's probably going to be used mostly for people bringing claims of copyright infringement, but it can also be used for asking the CCB to make a determination of whether something that could be infringing is actually a fair use and not infringing of copyright. So if you receive a cease and desist letter from a copyright owner and you believe that your use of that copyrighted work is non-infringing and it's a fair use, you can ask the CCB to determine that as well by just following that same procedure, by filing a claim and saying that you received this cease and desist letter, you don't believe that what's being accused of is actually an infringement, and asking the CCB to make that determination. So again, there's a lot of aspects of this process that have not been decided yet that the Copyright Office is currently considering. And they will be asking for the public for comments about how to best implement the CASE Act in a way that will be useful for those who use the system. So they've had an initial comment period. And as they start to implement rules, they'll be asking for more comments. And you can follow that progress at this link that's provided here. It's on the Copyright Office's website. So if you just search Copyright Office CASE Act implementation, this page should come up. Again, there's not a current proposed rulemaking. They just finished a notice of inquiry that just wrapped up its comment period, and you can read the comments that were filed. Many by organizations that represent artists, but also many by, organizations that represent large stakeholders such as Google or Amazon. So you can sort of see the different interests at play with respect to how this proceeding or how this copyright board will proceed and how it'll be implemented. So there's not a current proposed rulemaking, even though you can look at those from the most recent one. But the above webpage will be updated as the Copyright Office furthers the process. So as they start to actually go through these comments, consider their options and make rules, for example, about like how much the fee is going to be or how exactly that opt-out provision is going to work. And when there is an active rulemaking, if you have an opinion or a viewpoint to share, you can easily submit a short comment. So if this procedure is something that you think is going to be important to you, and if you have concerns or if you have ideas about what's the best way to go about implementing this procedure, the Copyright Office is seeking your comments on it. So you can definitely make your voice heard by following along with this rulemaking process. And again, I just want to underscore the importance of registration and registering early when you can. And, obviously not all, it's not practical for every artist to register every single one of their works. But if you know that something is going to be widely shown or widely available on the internet, that sort of increases the chances that it might be infringed upon. And what is that infringement? What is the value of that infringement to you? If you determine that value makes sense for you to have a larger potential claim, either in federal court or before the CCB with those statutory damages, then it might make sense for you to file a registration for your work. You can do so at this link provided here, the Copyright Office electronic registration system. You can also just Google it, it'll take you to the page. And the fees are $45 to $65 per work. So it's not prohibitively expensive if you're going to file a few works. It's relatively easy to do on your own, but consultation with attorney is still recommended. And if you need assistance, we're definitely available here at LegalARTLink to help with that copyright registration process or to answer any questions about it that you might have. If you have any more questions about this procedure here or about copyright in general or how to file a comment as they come up, please feel free to drop them into the chat, or you can of course always email them to LegalLink@locustprojects.org, an email that's provided right there on the screen. I'm more than happy to answer any questions you might have about this or generally about copyright or any other issues, of course. Thank you so much for joining us this afternoon. And I hope that, this is giving you some thoughts about how this copyright board might help to give you greater access and accessibility to enforcement of your copyright in the event that you find an infringement. In my work with LegalARTLink, we've assisted a lot of artists who have attempted to enforce their rights, ultimately to decide that filing a lawsuit in federal court was going to be too expensive or too big of a financial cost based on what they might be receiving at the other end of it. And it's definitely Congress's hope, it's mine as well, that this copyright claims board will help artists in pursuit of, that enforcement. And also to help users of copyright to effectively adjudicate fair use claims as well. So not seeing any questions, I'm going to go ahead and end the webinar now. But again, please feel free to reach out to us, legalink@locustprojects.org, with any questions you might have on this or any other legal issue. I hope you enjoy the rest of your afternoon and have a great rest of your week.